Hi everyone, Armine Bazikyan here, and in this video we wanted to talk to you about what to do with your original estate planning documents after you've completed the estate planning process. So primarily we'd like to discuss where you should put them or store them and how you should maintain these documents. So normally an attorney that drafts the documents for you will give you the original set of estate documents. You need the originals in order to administer the trust here in California. The originals are what we look for, and remember, in California, e-signatures, electronic signatures on estate documents don't work, so it is wet signatures that we get from clients. On those originals, we usually get wet signatures, and what our office does, for example, is we give our clients all of their original documents back with instructions on what to do, which I wanted to share with you today. So it's very important that you keep these documents in a waterproof and fireproof location. You don't have to necessarily keep them at home if you don't want to, but we recommend waterproof, fireproof location. If you have a safe large enough to fit all your documents, we recommend putting it in a safe. If you don't, there are usually waterproof, fireproof containers that are sold for document purposes. We recommend buying those. Now fast forward, when the person dies, we actually ask the trustee to submit all of the original documents to our office so we can help them administer the trust. If we can't find the original documents, there's always an assumption that the person destroyed them or did something with them. If they don't exist, then we have to be very careful with how we proceed forward. We have to ensure that we work off of a copy set and that it is the last known copy or version of the estate documents that the person had. So if the original is lost, we usually look for a copy set. And even in that case, case by case basis, we may use a copy set, or we may actually submit the set to a court and have a judge affirm that this is the latest version of this person's estate documents. Now I'll give you an example. I had a client who passed away recently. We cannot find his estate book, and unfortunately he had some assets that were left in his name and not in the trust name. So we have to go to court, and normally I would go to court and submit the will with some of the other documents that I had created for him, the original, and I would ask the court to allow us to transfer through the trust in what would be called a Hegstead petition. It's a more simplified version of a probate proceeding, a more cheaper version of a probate proceeding as well. It would save the family money. But in this situation, I can't do that for this client because we can't find his original will. The family scoured the entire house and it is nowhere to be found. So because the original will and original general assignment document is missing, we cannot submit to the court through a Hegstead petition, and instead we need to provide a full-on probate proceeding in order to transfer these assets that were in his name to the rightful new owners. Now, it is a case-by-case basis, and in this particular person's case, there are some facts that I'm not sharing with you, but this is the process that we're going through. So generally speaking, I really recommend you make sure that all your originals are in a safe place, and then make sure that your successor trustee or the person that's going to come after you actually knows where to find them and where to look for these originals. If you have questions, we'd love to hear them down below. Otherwise, we'll catch you in the next video.